Welcome to today's Lunch and Law at the new Civil Liberties Alliance. We're pleased to have you here with us today to talk about when your judge's boss is also your prosecutor. We have two distinguished panelists with us today. First, we have the Honorable Christopher Droney. Judge Droney served as a federal district judge for the District of Connecticut from 1997 to 2011, appointed by President Clinton. President Obama then appointed him as a judge on the U.S. Court of Appeals for the Second Circuit, replacing Guido Calabresi, where he served from 2011 until January 2nd of this year, when he retired from the bench. Judge Droney attended the College of the Holy Cross and the University of Connecticut Law School. He was in private practice in Hartford, Connecticut, until he became deputy mayor and then mayor of West Hartford, Connecticut, through much of the 1980s. He then served as U.S. Attorney for the District of Connecticut immediately prior to his appointment to the federal bench. He is now a partner at the Dave Pitney firm in Hartford, where he offers his expertise in several areas of litigation, including securities law. In 2016, Judge Droney dissented from the panel opinion in Tilton v. SEC, a case in part concerning the same issue NCLA has been working on in a few different cases. That is, whether there is subject matter jurisdiction in federal district court to hear structural constitutional challenges to administrative tribunals at the U.S. Securities and Exchange Commission. The panel in the Tilton case held that the district court lacked jurisdiction, but Judge Droney concluded otherwise. We are delighted to have him here with us today. Our second panelist is my colleague, Peggy Little. She's senior litigation counsel here at the new Civil Liberties Alliance, and Peggy was the first litigator hired to help build NCLA. Peggy has over 3 decades of experience as a trial and appellate litigator. She's a graduate of Yale Law School and Yale College, and she clerked on the Second Circuit for Judge Ralph Winter. Before joining NCLA, Peggy practiced from Connecticut as well, where she was a partner at Tyler, Cooper, and Alcorn in New Haven, and then a solo practitioner for many years. From 2004 to 2018, she also directed the Federalist Society's Pro Bono Center on a part-time basis. And Peggy has led NCLA's representation of Ray Lucia, Michelle Cochran, Christopher Gibson in their respective lawsuits, 3 different lawsuits, challenging the unconstitutionality of administrative law judges, or ALJs as we call them, at the SEC, and the resulting deprivation of due process that these NCLA clients have suffered. Peggy, thank you for being with us today as well. Judge Droney, may I begin by asking you to tell us a little bit about the Tilton case and why you decided to write such a comprehensive and detailed dissent in that case.
Sure, but first let me thank Mark and Peggy and the NCLA for inviting me today. It's my privilege to be a participant in this discussion. What got me interested in the Tilton case, she was the subject of an SEC investigation and sanctions for Investment Advisory Act violations under the expansion of the SEC's jurisdiction under Dodd-Frank. And what got me interested in first looking at the case was I just thought that by applying the Thunder Basin 3 factors to her situation, that the majority was just wrong about it, that if you applied those factors faithfully to her situation, it was unfair for her to have to go through the SEC administrative hearings and conclusions and then appeal to the Second Circuit at that point. So that's what judges do. We look for fairness and unfairness, and I just thought that this case was much closer to the Free Enterprise Fund case than the other cases, and it was really, that got me started and very much interested in this idea. And the other, maybe it's because I was a district judge for so long, it's rare to see jurisdiction stripped from district judges in deciding constitutional issues, and there's got to be a good reason for that, I think, especially an appointments clause issue like this, or any constitutional clause issue. I think it's much better to have district courts be analyzing and deciding those issues, and that's what I think the Constitution wanted, rather than an administrative agency, even though there's ultimately a chance for an appeal of a decision of the SEC in that case.
Sorry, I had muted myself. Judge, you mentioned Free Enterprise Fund v. Public Company Accounting Oversight Board, and wondered whether you might tell us a little bit more about that case and how you saw that interacting with what was happening in Tilton, and did you feel like that Supreme Court decision from 2010, I believe, should that have bound the Second Circuit in the Tilton case, in your view?
Well, it certainly should have bound like any Supreme Court decision if it applied to the Tilton situation. One of the, as you know, as you all know, who are watching today, the distinctive feature I think that many argued did away with the Thunder Basin three-factor test was the fact that there were no sanctions entered against the accounting firm in that case. So they really had nothing to appeal administratively. And some had interpreted that case to mean then as long as you have an administrative right of appeal, which ultimately may result in your appeal to the Court of Appeals, that's all that's necessary. And I thought that was much too limiting of an interpretation of the free enterprise case. And having read that decision now countless times, I don't think that's the reason that the Supreme Court said that we're going to reach the Appointments Clause issue. It wasn't just the lack of an administrative sanction there, it was the application of all three factors. And even in the subsequent case, the Elgin case, which decided that there was no subject matter jurisdiction in the district court, the Supreme Court in that case went through all three factors. And you can agree or disagree, but at least they did an honest application of the three-factor test from Thunder Basin. So I actually think all three decisions, Thunder Basin, Free Enterprise, and Elgin, are consistent in many ways. There's been a lot of scholarly analysis of those three cases, but I think that they probably came out the right way, all three of them did, and that Tilton should have come out the other way, in my view.
Do you think that one of the factors is more important than the other Thunder Basin factors, or do you think all three factors really need to be looked at with the same level of care?
Well, most of the opinions have said meaningful judicial review is probably the most important factor. The other two, as you know, are the claims collateral to the statute's review. What about the agency's expertise with this particular issue? Those are the other two factors. But it seems to be that the decisions are spending more time on meaningful judicial review. At least they're citing that factor. The problem, it seems to me, is most of them don't deal with meaningful, which is really the heart of these cases, in the Tilton case and the others. Is it meaningful to have to wait years to subject yourself to all the administrative proceedings of situation? Incur a fine, have your license suspended, probably not get a stay of the fine or the license suspension, and then go to the Court of Appeals. I think meaningful judicial review means something, and I don't think it's meaningful to have to wait 8 or 9 years and still have to live with these penalties before you get a decision made. And one thing that I thought was interesting is even at the time of Tilton, some of the judges were saying, well, she'll get a decision from us eventually. I don't think any Court of Appeals has decided this Appointments Clause issue in years. So it's not just in the Tilton case, but people say, well, it'll come and you'll get a decision and it'll be, the courts will treat it with real care. We still haven't gotten a decision on this Appointments Clause issue from a Court of Appeals or the Supreme Court. So I think that plays into the meaningful aspect of that factor from Thunder Basin.
Yeah, it's almost like jurisdiction delayed is jurisdiction denied. But Peggy, can you tell us briefly where Christopher Gibson's case stands, where Michelle Cochran's case stands, and where Ray Lucia's case stands as we're talking about how these how this lack of review by federal district courts leads to these delays?
I'd be happy to. Let's start. Ray's is the oldest case, and his proceedings started in 2012. As most listeners to this teleform will probably already know, he did prevail on the Appointments Clause question at the U.S. Supreme Court. And what the court ordered was all of the proceedings below were vacated, and he had to go before a different administrative law judge and start all over again. And we, after that case was remanded for Ray, we immediately brought suit in the federal district court saying, no, that can't be right because there's still a removal problem and he should not have to go through this proceeding again. We were unsuccessful in the district court, and I'll finish up in a little bit to tell you what his ultimate decision was. But Michelle Cochran is in the same situation. She already went through a complete administrative proceeding before the same administrative law judge who had ruled in Ray's case as well. And that case then was on appeal to the commission, and then the Lucia decision came down. Her proceeding was vacated, and she was told she had to go back and start all over again. Same thing is true for Christopher Gibson. He went through an initial administrative proceeding and got an initial decision on that. That was vacated by the Lucia decision, and again, his prize or his Pyrrhic victory is that he has to go back and start all over again. When I first got involved in this issue, some of the attorneys who've been dealing with this for a longer time than I have told me, you will soon understand the meaning of the term Kafkaesque, because this is what the situation is for Ray Lucia. I mean, he won, and his prize is you get to go back and go through another 6 year. It could be as long as 6 years. They're very, very slow, these administrative proceedings. And the particularly bitter pill, and this is true for Ray Lucia, Michelle Cochran, and for Christopher Gibson, is they still are contesting the fact that their administrative law judge enjoys too many layers of removal protections and so is invalid. If they prevail on that at any stage, they will have to go through a third proceeding. Now, if you talk to any layman and explain that you have to decide whether the judge who's going to preside in this administrative proceeding is constitutionally permitted to do so, any ordinary citizen would understand that's a threshold question. You have to decide that first before the proceeding commences. It's really that simple. And it is, it's been very difficult because these decisions, as they have been interpreted by the circuit courts, and in particular, 5 circuits court decisions, are an almost impenetrable barrier for us to get around. But we are determined to do so because it leads to such unjust and unconstitutional outcomes.
Judge, you spoke a little bit about this before, but I just wondered, to come back to it a little bit, as a former federal district court judge, whether you think a jurisdiction to resolve these issues belongs in federal district court on the front end, and in particular, why is it important for a trial court to decide the constitutional claims first, and then once it gets to the court, you mentioned already that the Tilton case never got back to the Court of Appeals, and that's been the case in some of these other cases as well. Why does it matter whether it's the federal district court on the front end or the federal Court of Appeals on the back end that makes this constitutional determination?
Well, I think one of the reasons is embedded in the 2 other factors under Thunder Basin, which is the issue, in this case, the Appointments Clause issue, collateral to what the SEC does? Of course it is. They don't decide constitutional issues, an ALJ, the SEC, especially on Appointments Clause cases. I mean, it's hard to find many cases in the district court that deal with Appointments Clause issues, but at least we do a lot of constitutional issues. The other is the agency expertise. Is there anything that the SEC does or its ALJ does that has anything to do with this issue of the Appointments Clause challenge in the Constitution? And the answer to both of those is the same. No, it's certainly collateral to the SEC investigations, nothing to do with what Ms. Tilton was accused of doing wrong with her agency. And the second is the expertise of the SEC has nothing to do with this new Appointments Clause issue of whether the layers of protection for these ALJs is constitutional under the Appointments Clause. So that's very troubling to me, and was at the time. The other thing that's troubling to me, that one of the reasons why I think the district court should get these, is in your petition for cert in the Gibson case, you point to the statistics. After the Dodd-Frank legislation, where now the SEC has the choice of going through its own administrative law judges or going to district court, 77% of them go to the SEC path rather than the district court. There's no surprise there because it's a more favorable environment. And if you look at the results that are set forth in your petition as well, they win far more times in an SEC ALJ case than they do before the district court. It has no, has no stake in this. It's totally independent. Those are very troubling statistics, I think, for a district court to see, much less you have an SEC ALJ who's, I'm sure, perfectly capable in deciding a SEC violation, but not as capable in deciding a constitutional issue, and certainly not as capable as the district court and then the Court of Appeals in a more speedy review than 10 years later, if ever, to a Court of Appeals.
Judge, what do you say to folks, and Peggy, I can throw this question to you as well, but Judge, what do you say to folks who say, well, the reason that the ALJ needs to decide this question first is because the ALJ might decide in the litigant's favor, and then we never have to reach the constitutional questions, sort of a constitutional avoidance theory of jurisdiction, if you will?
Well, it's certainly possible, but I think it's unlikely. If you look at the record of decisions of the SEC in the SEC's favor compared to the district court, you'll see you have much less chance of winning going through SEC ALJ. Do I know the reasons why? I don't, and they probably vary from case to case. The other troubling statistic here is the number of cases that settle. That a lot of these targets of the SEC investigations settle their case, over 90%, I think, or close to 90%, because they don't want to go through this. They don't want to have to endure 8 years where their license is suspended and they're paying a big fine. They settle the case and it's all gone. We don't get to see this in any court ever. So I think that's a troubling statistic as well, is how many of these cases get settled.
Well, and maybe Peggy, you want to mention Ray Lucia in that regard.
Yeah, well, and I want to say that the SEC self-reports that the settlement rate is 98%. So you are talking about virtually every case settles. And one of the reasons they settle is they...
Well, I think it looks like Peggy's paused there. So Judge, let me come back to you on this question of the federal district courts. And one of the concerns I have is that even if somebody does prevail in front of the administrative law judge, they're still not going, and Peggy, we'll come back to you in just a minute, but you were frozen for a second. Judge, even if they prevail in front of the administrative law judge on the securities question, if the ALJ is constitutionally not allowed to be hearing that question, then does it really matter whether they prevailed or not? All they're doing is getting a victory from an invalid tribunal, and that may let them off the hook, but then we never get this constitutional problem with the agency resolved. I
agree with that. And still, like I said at the beginning, it still hasn't been resolved, and this issue has been around for at least 10 years. So no Court of Appeals has ruled on the layering of tenure protection and whether it violates the Appointments Clause.
Peggy, you were starting to talk about Ray, sorry.
Sure. And I hope the panel participants heard that the settlement rate is 98%. Yes.
You were cut off right after that.
Okay. And this is important for any number of reasons. As Mark just stated, it renders the constitutional injury permanent, even if someone were to win. But when you settle, that means that has a lot of consequences. Reputational, it has, to the extent someone needed judicial review to have the removal question heard, that never gets heard. Also, and this is a separate issue, but I just want to mention it, when you settle with the SEC, you are silenced for life, and you can't even talk about your case. And that is a way that the SEC is very successful in hiding how these proceedings deny constitutional rights to the respondents who are charged. And it's So the settlement percentages and the pressures on people to settle because they simply can't afford a multi-year, sometimes approaching a decade fight. They can't afford it. It's very troubling.
Yeah, Ray Lucia is a great example. He spent over $1 million in defense costs and wound up as a pro bono client of the new Civil Liberties Alliance because he ran out of money to continue the fight against the SEC. It's just a battle of attrition, or as Peggy, I've heard you often use the analogy to Sisyphus. I mean, people, it's hard enough to roll this boulder up the hill one time, but expecting anybody to be able to roll this boulder up the hill 3 times just to get an answer to their constitutional question is nearly impossible from a practical standpoint. Judge, there's another
Mark,
aspect.
can I just add something about that? What Peggy just said, and that is, I think it should be stated, at least in my view, the SEC and their ALJs do a lot of valuable work for the country. I mean, there's no question that the increased supervision by the SEC following the recession in 2008 is necessary. And I think all of us would agree with that, and that we have to make sure these markets are watched closely by the SEC. Are they right all the time? No, I'm sure. Are they right many times? Yes, I'm sure. But the question is, who should be resolving this important constitutional issue? They're very good at SEC and securities issues resolution. They know what they're doing most times, but it's different when it's a constitutional law issue. I don't think you should have ALJ administrative judges deciding that when it has such an effect too on so many people and the industry. So I think it's worth saying, and I'm sure that most of the people participating would agree with that.
Well, and I think there's a conflict of interest there too. If ALJs are deciding whether their own appointment was constitutional or not, that's a tough thing to expect any jurist to do. That's the kind of thing I think that we would expect recusal on ordinarily. So I don't know that, I think there might be an additional concern from that perspective. The question I was starting to ask you, Judge, is does it bother you that litigants in these SEC proceedings, so folks who've gone all the way through the administrative process, they've gotten their appeal to the commission, they've gotten their ruling from the commission, and now they're ready to go, in your case, it would have been go to the Second Circuit Court of Appeals and contest that ruling. Before they can make it to the Second Circuit, there's one more step, and that's that they have to pay the fine to the SEC. They have to pay that penalty. And that wasn't true in Thunder Basin itself, but it is true in these SEC cases. I'm wondering if that's a concern to have that sort of financial barrier between the ALJ process and the backstop of Article 3 review of the ALJ process.
It is, especially given the statistics of how often a stay of those penalties or sanctions is granted by the SEC pending even administrative review. My understanding is it's fairly rare that you can get a stay of those. And the other troubling part of this too is that they do have the right after the ALJ rules to go to the SEC for review. But so few of those appeals to the SEC also are successful. So you've got a lot of real world impediments here to having some justice done, I think, for the targets of the SEC filings. Those are some other factors that trouble me as well. Absolutely.
Peggy, can you explain a little bit more about how these administrative proceedings differ from court proceedings? I mean, we understand the SEC has a choice in many cases as to which direction they go, but what's the difference for the litigant or for the defendant?
They're quite dramatic. The rules that apply in the administrative proceeding are very commission friendly and do not give respondents the same rights they would have in district court. For example, the administrative law judges do not need to follow the federal rules of evidence, the federal rules of civil procedure. There was evidence from one ALJ that spoke with the Wall Street Journal that in her opinion, when you are in the administrative proceeding, the burden has shifted. Practically speaking, if you're before the ALJ, the burden is on you to show why they don't have a case against you. Whereas in federal district court, the government would bear the burden, which is as it should be. There are rights to have witnesses speak on your behalf. The ALJ has very broad discretion to deny that. You don't get
That's
any.
not just any right. That's a constitutional right in the Bill of Rights.
Absolutely, and I will illustrate this for our participants. In Ray Lucia's case, he asked a couple of customers, clients of his, who were very supportive of his case and who felt that they had not been misled by anything that he had said. And Ray's case is particularly compelling because no one, at any stage of proceedings, claimed that they suffered any losses or damages or had lost money. But he wanted to bring on some witnesses. Right before they were to testify, the SEC hit them with subpoenas demanding production of 5 years of all of their financial records in any form whatsoever under penalty of perjury. Well, obviously witnesses are not going to want to open up their lives like that to a regulatory agency just to go and speak on behalf of someone who's before that agency. That would never be permitted in district court. And he was denied to have witnesses speak on his behalf. And that was a dramatic and important problem. It was also very interesting to me that Justice Kagan unusually ordered that the ALJ should not sit again on Ray Lucia's case. As I'm sure Judge Droney will confirm, that's a very unusual thing for the Supreme Court to order. Cases are remanded routinely to the same judge who heard the case the first time. But there were disturbing things about Ray's particular judge, who had said in settlement negotiations, for example, had told respondents that they should understand he has never ruled except in favor of the commission. He also said he would always give the maximum lifetime ban to anyone who contested their charges. Those are deeply troubling statements. That ALJ is no longer with the SEC, interestingly enough. And you also don't get jury trial rights. But one thing I thought of today in preparing for this that I think is also a very important and not well understood problem is that I started looking at how long it would take, for example, Michelle Cochran to get her case heard in the Northern District of Texas. And the average time from filing to resolution there is about 22 months. And I started looking at these statistics in the federal courts. Whereas Ray Lucia, it took him years to go through the administrative proceeding. As Judge Droney points out, then you have the commission review. In two of these cases, which will be familiar to us who are speaking today, Jarcasey is one and then Bebo is another. Those people just got their decisions from the commission now. That's 5 years into the proceedings.
Just within the last month or so.
Exactly. And so one of the things that I think people don't necessarily think about is courts are quite disciplined administratively. District judges that don't move cases along or that keep them too long, or appellate courts that do not move their cases to resolution, those statistics are demanded of them, and there are consequences when you are not providing people with fair and as swift justice as you can do. There is no such discipline in the administrative proceedings. The administrative agencies know this. And so what Marcus said, I like to call the Sisyphusian process of pushing this rock up a hill.
I think you can pronounce that. I'm not sure I can.
Well, I hope I did it right. But I think those familiar with the myth understand what I mean. But it's not even administrative exhaustion, it's annihilation of people to have to go through these proceedings that maybe 5 years before they can get before a district court. And the administrative agency knows that. No wonder 98% of people settle.
Judge, what do you take from the lack of the federal rules of evidence and the federal rules of civil procedure and some of these important protections that are instantiated in the Bill of Rights not applying in the ALJ situation? Is that something that can be corrected at the Court of Appeals level, or if you're looking at an administrative record that was created without the benefit of the FRCP or the Federal Rules of Evidence or the ability of witnesses to testify and so forth. Is that something that the Court of Appeals can readily correct?
Probably not, but I think we'd all recognize that. I mean, there's a reason why there's more latitude in administrative hearings. There's more of them. You're trying to achieve basic fairness. You have to keep the trains running in these administrative proceedings. So there's a reason why you don't require strict adherence to the rules of evidence or the rules of civil procedure in many of these administrative proceedings. So we all get that. But to answer your question more directly, if you've got that latitude before the administrative law judge, the chances of your awarding the appellant in that case on the basis of an administrative decision on evidence or procedure is very, very small. It's kind of small in an appeal from a district court. You have to show that it was real error in the case if there's an evidentiary decision that went the wrong way. So there's even some latitude given district courts, and I was a district judge for 14 years, and there's reason for that. But when you move to an administrative proceeding where there's not strict adherence required, the chances of prevailing on those kinds of claims is very, very small.
Sure. Judge, did you notice in your time on the bench any more general reluctance, sort of outside of this particular issue, any more general reluctance of courts to defend federal court jurisdiction? I mean, is there a tendency, either as courts get busier or for some other reason, to be stingier about jurisdiction or to construe statutes more narrowly? Or is that something that you didn't observe outside of this context?
I didn't really observe it generally. I can't say that. I just, in this context, I observed, I concluded that way. But I will say that, and this is just my own observation, is that oftentimes you'll see courts state the three factors that have to be applied, like here, Thunder Basin. But there's not a rigorous application of those. You know, and that's what bothered me here is, how could you say this was not collateral to the case? And in my case in Tilton, they said basically because it was raised by way of a special defense, it's embedded in the proceeding. Well, I mean, so what? It's still an issue that's totally collateral to what the ALJ has to do in that administrative hearing. The Appointments Clause issue has nothing to do with the reason that Ms. Tilton was brought before the SEC. And it has nothing to do with what the SEC does on a day-to-day basis. The same is true of the agency expertise. There's a reason for that in the two other Supreme Court cases, Thunder Basin and Elgin, where you may have to rely on some administrative people who deal with the Mine Act or deal with employment appeals of federal public servants and bring some expertise to bear on those that might affect this issue in a significant way. Like I think in Elgin it was, they had to decide constructive discharge as a threshold to considering the discrimination claim, the employment discrimination claim of this group of men who were challenging the Selective Service Act. So and it was stated as one of the three factors in the Tilton case. But how in the world is the SEC experienced in Appointments Clause issues that somehow would help the district court make that decision? So that's troubling at times, where sometimes you see, okay, here are the three factors, but then the collateral issue factor is decided in favor of the SEC just because there was a special defense filed that raised this, because you have to raise any claims or else you waive them, or the agency expertise issue. We conclude maybe there's something with the SEC knows that might be helpful here. Well, that's not true in the Tilton case. There's nothing about the Appointments Clause case, situation that they could bring to bear that would help the district judge out or the ALJ in deciding that issue. That's probably not true in Thunder Basin or in Elgin, where there might be some help provided by experts, administrative people who've had these situations in the past. So I would say it's a long way of saying that what troubles me at times is the court restates the tests correctly, but then kind of doesn't do a good job of applying those tests to the situation at hand. And that was troubling to me in the Tilden case.
Peggy, I think that Judge Haynes was singing from the same song sheet as Judge Droney was just singing from in her dissent in Michelle Cochran's case. Do you want to talk about that at all? The sort of the disregard for the three factors, if you will?
Yes. Judge Haynes, as did Judge Droney before her, actually looked at all three factors and rigorously applied them. And all three, honestly interpreted, argue in favor of federal court jurisdiction. I will add, and in this, I think, when I argued Michelle Cochran's injunction motion, the court seemed to hear this point. In Free Enterprise Fund, when they were going through that jurisdictional decision, which by the way was unanimous, that portion of Free Enterprise Fund was a unanimous decision of the United States Supreme Court. They said it was beyond agency competence and expertise. That's a direct quote from a controlling Supreme Court decision. To me, that just takes that factor and decides it for any lower court, because it obviously is beyond agency competence to be deciding constitutional questions having to do with the capacity of their judges to sit, especially when it's that judge. Mark, you brought up the recusal issue. Judge Droney also talked about the fact that some of these courts say, well, it's a special defense or an affirmative defense in the proceeding, therefore it's sort of intertwined. One of our amici in Cochrane just did a terrific job of blowing up that notion. It's actually not an affirmative defense at all. It has to be pled that way just because there's no other place to put it in how you plead in an administrative proceeding, which is very informal. But an affirmative defense, as anybody who's practiced law for very long knows, is a defense that means notwithstanding everything else, you, the plaintiff here, don't have a case, okay? The disqualification of the judge or whether they have improper removal protections or have been improperly appointed has nothing to do with an affirmative defense. And so that's a good example of reasoning that is typically used by these courts that simply does not stand up to analysis.
Judge, I recognize that there's a difference between the appointments cases and the removal cases that have been heard in the federal courts of appeals. The question of whether there's subject matter jurisdiction before the ALJ hears the case is the same, but the constitutional appointments question has been resolved in the Lucia case, and it's now this question about multiple layers of removal that hasn't yet been decided. But I just wanted to ask you, why do you think that the courts or judges have been so reluctant to create a circuit split on this subject matter jurisdiction issue? Are they just reluctant to buck the trend once a few circuits have gone in the same direction? Because I would think when the Supreme Court appears to be on the other side of the split, that courts would be more willing to jump into the fray, if you will.
Well, I never really believed that when we were deciding a case that we just kind of weigh how many circuits went one way and how many circuits went the other, and we're going to go with the majority. I don't think it's that. I don't think judges do that. Although I do think maybe it was in the Gibson case where I think Peggy sent me the opinion where the court said, gee, there's now 5 circuits that went this way. That means something, that. And what they really, I think that judge meant like, well, maybe that reasoning is correct, rather than we're just weighing how many courts of appeals went one way. But it creates, it certainly creates some momentum. If you have 5 circuits saying it's okay to wait until the administrative proceeding is over. But I just don't get it. I don't know why they think in these kinds of cases, those other 2 factors in Thunder Basin are either don't apply anymore or are satisfied. I don't think, I reread all the Supreme Court cases in the last couple of days, and I don't think Elgin did away with the other 2 factors, the agency expertise and the collateral issue. It cites it, and I think it honors it. You can disagree with the result maybe, but those factors from Thunder Basin still survive, all three of them. I just don't think that they're applied all that thoroughly, where you really think about it and say, well, is the agency really adding something to the analysis, either in the collateral issue factor or the agency expertise? And I haven't heard on either of those convincing arguments. So what that you raise perhaps this issue in what really are kind of like the pleadings in the administrative case, but you have to do that. If you're the lawyer, you're not going to take a chance of not raising this issue. So that, but then they say, well, then it's embedded in the administrative case. Well, it's embedded because the lawyer didn't want to take the chance of missing this, so he couldn't raise it. He or she couldn't raise it in the Court of Appeals 10 years from now. That's why you do it. If you're a real lawyer, you say, we've got to put it in because I don't want to have somebody say in 8 years in the Court of Appeals that you forfeited this issue. So I just think it's more of a real hard application of these, all three factors. I think meaningful judicial review is the hardest factor because what is really meant by delay? Because there's a lot of cases, and they're all cited, saying that that's the way court proceedings go. You have to wait until your rights are vindicated, maybe on appeal, and that's too bad. That's the way we do things in our system. But I think there's some, I think meaningful means something. Otherwise, you know, it wouldn't be part of the test in Thunder Basin. So I guess that's a long way of saying I just don't think they're real faithful application of the three factors.
I should tell our audience we will take questions from the audience starting at 1 o'clock. We'll have a few more questions for Judge Droney and Peggy before then. Judge, one of the things that I find frustrating is that in the Lucia case, the Supreme Court recognized this issue about the potential multiple layers of removal. Justice Breyer in particular recognized it in his separate opinion. And it seemed like the court really wanted to wait for that issue to percolate in the federal district courts before the Supreme Court wanted to weigh in on it. And yet all of these lack of subject matter jurisdiction decisions essentially guarantee that this issue isn't going to percolate through the federal district courts anytime soon. And I could be wrong, but I could have sworn that it said district courts. Maybe it said lower courts. Maybe Peggy remembers. But I don't think they were necessarily looking for percolation just from the courts of appeals. I think they were looking for a district court view here as well. And they're not going to get it if there's no subject matter jurisdiction found.
I think that's a real good question. And I don't know what the Supreme Court was thinking of, because after Lucia, of course, what happened was all these administrative judges were now appointed by the SEC, not just applying to the Human Resources Department of the SEC. So that was an easy fix after Lucia for that issue, but it didn't resolve the whole question of satisfying the appointments clause. So, you know, I guess that in my 8 years on the Court of Appeals, you get used to deciding the issues that you need to decide to resolve the appeal, but you also have peripheral vision too, as Judge Cabranes would say, to say, well, is this going to come back? I mean, why don't we just resolve this now rather than wait another 5 or 6 years until the Supreme Court gets it again? But maybe they thought that it wasn't going to be such a quick fix. I don't know.
Okay. Peggy, do you think these cases would be decided the same way today, some of these cases post-Lucia, as they were decided before?
Well, that's an interesting question. I think the Elgin case is an interesting case because of who is in the dissent that was written by Justice Alito and joined by Justice Ginsburg and Justice Kagan. And some of the justices that were in the minority are no longer with the court. So, but the Elgin case is easily distinguishable. I agree with Judge Droney. But I'm not convinced that Elgin would be decided the same way. There's a very good argument made in the dissent as well. But our hope when we took over Ray's case and Michelle's and then Christopher Gibson's as well was that, you know, when the judge refers to peripheral vision, we pointed out in every one of those proceedings that that the government itself had admitted in in its briefing to the U.S. Supreme Court that these removal protections were unconstitutional. There were too many layers. They even enumerated there were as many as 3 layers. And then why a district court could not see, when they have right in front of them Ray Lucia, who's already gone through this extensive, impoverishing process to vindicate his point on the appointments question, why they would deny jurisdiction to him to address a removal problem the government admits is there, that Justice Breyer says is an embedded question, was a mystery to us. It seemed that a district court would recognize that there was a time to address that, and that is before the administrative proceeding started, so that these people would not have to go through this entire process all over again, because even if they prevail, they're back again for a 3rd trial. Now, no rational system of justice would operate in this fashion, and we think in fact, the laws don't provide for that. These administrative proceedings are put into place so that the ALJs can decide violations of the securities law. There is absolutely nothing in what Congress has delegated them to do that even remotely empowers them to decide constitutional questions. It's that fundamental.
So Mark, I think I told you earlier before we got started, I had a question for you.
Yes.
So
yeah, you warned me. But you didn't tell me what the question was. So
I didn't. You didn't tell me my questions either. So this is the question. I'm not a member of your organization, but I understand that, I may be wrong about it, that you also feel that Chevron and our deference should be revisited, and there's some talk on the Supreme Court about that, especially with Justice Gorsuch. Here, one of the Thunder Basin factors is getting some expertise from the agency. And it's true in Elgin, and it's true in Thunder Basin, that that would be helpful to a resolution of some of these issues. Is that factor in Thunder Basin consistent with trying to change Chevron and our deference? How do you think is there any connection between that?
That's a great question. So let me back up and say one thing. I almost jumped in with this earlier, but held off. But I think it's relevant to your question. When we first got involved in the Lucia case as an amicus in his Supreme Court case before he was a client, we discovered that the ALJs at the SEC, in fact, don't have securities law expertise. None of the 5 ALJs at that time had come from securities practice, either on the prosecution side or the defense side. Some of them one had come from the FCC, I believe. One of them had come, or I think more than one had come from the Social Security Administration. And so the idea that the ALJs are somehow bringing expertise to bear, really, I think what we said is that the emperor has no clothes on this expertise issue. And to the extent that they do develop expertise, because if you've been an ALJ for 20 years and you've been hearing these cases, I don't want to suggest you don't have expertise built up, but I would suggest that you've learned the securities law through a particular prism, and it's through the prism of the prosecutor, and that probably affects the way that you think about these issues. And so I'm a little bit maybe less sanguine about the expertise that the ALJs bring to bear than some of the justices maybe are, or some of the other kind of cases that you referred to would be. Now that said, with that caveat, I don't think that NCLA's position is that judges should not take into consideration any expertise that the agency has. It's just that they shouldn't defer to the legal judgment of the agency. Certainly, whatever persuasive power that the agency's viewpoint has is something that courts should listen to and take into account and recognize that it's being spoken with a certain amount of authority. Where we have a concern is when these deference doctrines come into play in a way that really prevents a litigant from having a fair shake. If the court is going to defer to the legal judgment of one of the 2 parties in front of the court, well, then the other party isn't getting due process. At least that's our perspective. And then we also think that folks like yourself, who are Article 3 judges who have sworn judicial oath, that have a duty under Article 3 to provide their independent judgment, that you're not really providing independent judgment if you're deferring to the agency's view of things. Again, perfectly fine to take everything the agency says into consideration, and if you're persuaded by it, obviously your judgment should lead you in that direction. But I think there's a big difference between persuasion and deference, and that's really where we have been trying to come down on that issue, if that makes sense and answers your question.
It answers my question.
Okay.
I'm not going to concede that it makes sense. I'm just giving you a hard time. I don't quarrel with you on that. It's just that in my experience, both as a district judge and a Court of Appeals judge, is that you get into such esoteric areas that it's hard to be able to understand it as well as people who do it every day. And so that, whether it's deference or just help, I think is the difference. I always thought that it was at least helpful to have somebody who worked in that area that you had no background on, especially when on the Court of Appeals, most of us are generalists. We were not, I had a case involving organic chemistry. Well, I was a history major in college, so it was hard for me to get up to speed on organic chemistry. So,
sure.
That's for another day, I think.
Yeah, well, absolutely. And maybe we'll have to have you back to talk about that. I do think it's an interesting area. There's been discussion of whether judges should appoint more special masters, or in some of the antitrust cases, I know they've appointed folks to help the court with an independent perspective, at least in theory. Peggy, do you? We were talking a little bit about the delay and the impact that this has on the litigants in these cases. But I was wondering, and you were talking earlier about the fact that the district court judges have supervision, and if they let something linger or languish, that they're going to hear from it, maybe from the chief judge or at least from the administrative office of the courts. But in the case of the ALJs, I guess I wonder, who's guarding the guardians there? Is particularly if the agency benefits from delay, which I think it might in some cases. What incentive is there for the agency to make sure that the ALJs are bringing these cases along? And obviously, the ALJs themselves may feel duty bound to operate with alacrity, but just from an incentive structure, is it different for the ALJs than for the federal courts?
I think so. I'm certainly unaware of any. I guess I would call it administrative discipline that tracks how these administrative cases are moving, and are they moving appropriately. What I am seeing, not just from clients we represent, but many people who call us and ask us to represent them, is that these proceedings go on forever. There are also some disturbing aspects of the proceedings. I've given a list of some of the due process issues, but they have mandatory deadlines that the hearing is to commence, for example, very quickly. That usually happens, and that's a problem in and of itself, because the respondent has very little time to prepare their case and have adequate discovery. And there's been many reports of what are called document dumps, where the SEC or other agency has investigated you for 5 years, and you've got 60 days to prepare for trial, and they give you so many documents that no law firm, no matter how well staffed, could go through them. And that's a due process problem, and it's a serious one. But then when it comes to rendering the decision, which they're supposed to do in 300 days, judges, the administrative law judges, routinely just move that deadline. And by the way, that deadline is mandatory under the rules. And they just, we like to call them magic deadlines. And it's, so they're giving themselves leeway that they actually do not have under the rules. It certainly operates to the prejudice of defendants. And one of the things, and I'm going to be quoting the Enforcement Division Director, Andrew Cerezny, in 2014, he in a speech said, well, we realize that these are proceedings that deny certain due process and procedural rights to people, but we want to produce prompt decisions because it's important to all the parties, because proof at trial rarely gets better for either side with age. Memories fade and the evidence becomes stale. And I can tell you from having represented Ray Lucia, even finding witnesses.
Or Michelle Cochran is another.
Yeah, or any of them that would remember what happened 5 years ago. And then when you look at the statistics that in district court, it's about 22 months to resolution. And then you see these cases, Cochran, Lucia, Mr. Gibson's case, Bebo, Jarkissi, where it's 4, 5, 6 years. That's a dramatic difference that makes it extremely difficult for someone to prevail at a proceeding that has already got so many procedural blocks stacked against them.
Well, in Michelle's case, if I'm remembering correctly, one of the people who would be in a position to testify about what she did or didn't do correctly in the auditing process was one of her fellow employees who is now older and suffering from some severe medical issues and memory problems and is no longer really fit to testify in that case. And so she's lost the ability to have a witness that she would have had if the case had gone forward in federal district court right away, rather than languishing for as long as it has.
That's true. And I think there are serious questions about whether the important documents she would need for her defense are even around anymore.
Yeah. Well, let me go ahead and start throwing this open to some questions from the audience. And the first one that we have is from Richard Samp, and he asks, has the SEC ever examined and issued an opinion on whether the double layer of tenure protection violates the separation of powers? And if so, how does it distinguish the free enterprise decision? Peggy, do you have thoughts on that?
Yes, well, the decisions of the commission came down in Jarkissi and in Bebo just very recently. And they, in a fairly predictable fashion, said, no, these removal protections are just fine. They attempted to distinguish the free enterprise decision. I don't think they do. I don't think they effectively do so. I don't see how they could. And it's also a very important fact that gets lost in all of this. And when you talk about the commission as a level of appeal and review, the commission doesn't have the power to decide constitutional questions either. And in fact, in Ray Lucia's own case, 2 commissioners dissented on the appointments clause decision in that case and pointed out that while the commission is free to express its opinions on constitutional matters, this must be decided by an Article 3 court. So you have actual commissioners of the SEC agreeing that that is not within the grant of powers to the agency to be deciding at all in the first place.
Judge, did you want to add anything to that?
Not really. I don't know it as well as you folks do, especially Mark and Peggy, but I guess the only thing I would say is that, you know, the SEC also has, I don't know how many, but a lot of ALJ, administrative law judges working for them who have at least expected that they would have the for cause protections before they could be dismissed. So that again is kind of an institutional bias. I'm not saying the commissioners decided on that basis, but if they decided the other way, they'd be telling all these ALJs, look, you can be discharged and you don't have for cause protections anymore. And my guess is that that weighs a bit in their decision.
Sure. The next question comes from Glenn, and Glenn asks, NCLA filed an amicus brief in Axon's fight to make their constitutional case against the prosecutor, judge, executioner approach of the FTC. What's the status of that litigation? Peggy, are you familiar with the Axon litigation?
Yes.
Can you have an answer to that?
Yes, we've been trying to help out on that case. And this is an important thing, I think, for our the people attending this to understand. This case is not limited, this problem is not limited to the SEC. And it's going to keep recurring in other agency situations. The FTC case in the Axon situation is particularly compelling because at the FTC, you never win. They have a 100% win rate before their own ALJs, and that's been the case for, my understanding is decades. So if you're brought before the FTC ALJs, good luck to you. And that's a real problem. But the status of that case right now is that Axon has moved for an emergency stay from the Ninth Circuit, pending the Ninth Circuit decision on the removal question. I wish them luck. I actually sent them the stay papers that we had filed in Lucia and Cochran to help them along. But that's where they stand. And one of the problems, and this is what caused Ray Lucia to finally throw in the towel. We had his appeal at the Ninth Circuit completely briefed. And the time from that to decision is estimated to be at least 2 years. Ray Lucia was 70 years old. He had lost his entire fortune for a charge that never harmed anyone or caused anyone losses. And he just simply did not have it within him to endure another, what looked like it would be 6 years or more before he would be vindicated. And then his prize is a third trial.
Sure.
People can't do that.
I don't want, Peggy, I don't want to get out of this luncheon law without talking a little bit more about Christopher Gibson, since he's the one that has a cert petition pending at the U.S. Supreme Court. And I know you've been extremely involved in that. NCLA is fortunate to have former Solicitor General Greg Garr as the counsel of record in that case. But one of the things that happened in Christopher's case that I found alarming is that his first time through the ALJ merry-go-round, the SEC had, what's the polite way to say this, shared some inaccurate information with a key witness in his case, who then was very aligned against him or aligned with the SEC's theory of the case, refused to testify in Christopher's behalf. As time passed and the truth came to light, that changed. And so when Christopher's case went back in front of an ALJ for the second time, this key witness was able to testify and I think made a big difference in Christopher's case. And yet, I just think it's another example of what you were talking about with Ray, with the witness, that this wasn't witness intimidation, but I think it was a little bit of witness manipulation, if you will. And I'm just concerned, and I wonder if you think those sorts of factors will weigh into the Supreme Court's interest in this case at all, or whether you think they're really just going to focus on the legal question that's presented in the question presented in the cert petition.
Well, the short answer is they will probably focus on the legal question because they're so used to not looking at facts. But one of the interesting and sort of surprising things in the Lucia case was that Justice Kagan seemed to be bothered by his case going back to that same administrative law judge who had acted in ways that just aren't defensible. And I think that whether it be in the Supreme Court's decision-making or in the important work that we're trying to do and other like organizations are trying to do, we need to talk about these things. The fact that the SEC can essentially poison a witness against the respondent, and that worked terribly against Christopher in his first hearing. Now, by the time of the second hearing, that witness had come around, but there are also very serious issues in his record about the fairness of the SEC expert opinion. The administrative law judge, in fact, admonished the government's expert for being evasive and refusing to answer questions that were clearly, within what he was able to answer. So there are a lot of things that go on in these proceedings. They don't see the light of day the way court proceedings do. and they don't have the procedural protections. And those protections are there for a reason. Centuries of work have gone into the federal rules of evidence and federal rules of civil procedure in order to protect people from unfair surprise or witness intimidation, or telling a witness something that proves to not be true, and it greatly affected Christopher's first outcome.
The next question we
Can I
have
just say
from the
something about
audience.
that?
Oh, I'm sorry. Go ahead, Judge.
Mark, can I just? Yeah, I just wanted to say that, of course, the biggest problem with the Gibson petition is that there's no circuit split. But I thought you did a great job of making the point is that even though there's no circuit split, this is compelling. That this is a case where you still should take it. And my guess is the Supreme Court has these cases, and they don't just, say we're just going to decide circuit split cases this term. And so I thought you made a really good argument. I thought it was very well done. How even though there's no circuit split, they should take this.
Well, thanks. I appreciate that, Judge. I think one of the things we tried to bring out was the fact that there may not be a circuit split, but almost all of the circuits that actually get securities law cases have weighed in on this question now. So the chances of something percolating up from one of the other circuits, I think there's only one circuit that has any sort of volume of these cases that hasn't weighed in on the question yet. So we could be waiting a long time if we're waiting for one of the other circuits to weigh in on this.
And I'm working on a circuit split too in the fifth.
That's right. We're seeking rehearing en banc in the Fifth Circuit, and the government has been instructed to respond now. So we have not given up hope in the Fifth Circuit. That's an excellent point, Peggy. Our next question is from Randy Gregg, and I'm going to ask the question that he posed, and then I'm going to put a little addendum on it. So his question is there any movement legislatively to attempt to reduce the penalties in the Sarbanes-Oxley Act, as the penalties don't appear to fit the offense? It seems very extreme in how it's being applied by the PCAOB. And I guess you guys may have answers to that. That's a little bit outside of my ken. But what I was just going to offer as maybe a slightly different question is whether there's anything either about Sarbanes-Oxley or about Dodd-Frank that you think is making this problem of these administrative hearings either better or worse?
Well, the questioner was asking about legislative solutions. Am I correct?
Yes. Attempts to reduce the penalties in the Sarbanes-Oxley Act was the specific question, whether there's any movement there legislatively.
Right. I'm not aware of that, but I am aware of some legislation that I think was being proposed from someone from New Jersey, and I'm not recalling the congressman's name, but I thought it was a really interesting fix for this problem, which is just as the SEC has the option to bring these actions in the district court or administratively, that option should be given to the respondent as well. So that, let's say this is a relatively minor matter, you could have it resolved administratively. That would be kind of like referring the case to a magistrate judge in the district courts. But if the respondent feels that it's an important constitutional question, or just simply that they are being wrongly charged and they want all those procedural protections, they should have the option to have their case heard in federal district court. I think that's an excellent piece of legislation, and one that would go a long way to correcting some of these
one-sidedness.
Yes, exactly. Imbalance.
Judge, my understanding is that in federal district court, if both parties agree, then you can proceed in front of a magistrate instead, but that it requires both parties to agree. Is that right? And is there any learning from that we might take to the administrative law context?
Well, you are right about that, that you have both sides need to consent. But I think that the principal reason that both sides consent is that you can say to them, look, the magistrate judge has time for the trial October 15th, so that you can get, I've got 3 criminal trials backed up. You're not going to get to me for a year and a half. That, I think, is, and it's true most of the time, or all the time. And that's very persuasive, where they say, as long as you can identify the magistrate judge too, so that they know that it's this particular magistrate judge that they really admire and like, then that helps too. But usually it's a question of timing. They say, I'd rather have my case tried in a few weeks rather than in a few years. So that's the most helpful part of it, I think.
Okay.
And by the way, I should say, you know, we haven't talked about the virus at all, thank God, for our hour. But I will say that I've been doing a lot of webinars on remote proceedings. And one of the things that's going to happen is, because we haven't had any jury trials to speak of since February, and now the courts are trying to do jury trials, that's all that the district courts are going to be doing for the next couple of years, especially with speedy trial problems on the criminal side. So it's going to be hard to get a district judge to hear your case, but you might be able to get magistrate judges to do it. And my guess is there's going to be, on the civil side at least, there's going to be a lot more magistrate judge trials in the next couple of years.
That's an excellent point. Judge, are there other constitutional issues? This question comes from an anonymous attendee. The question is, what constitutional issues other than the Appointments Clause issue might be decided in the first instance, or should be decided in the first instance by federal courts? Were there any other things that maybe came to you at the Second Circuit on appeal from a administrative proceeding where you thought, gee, maybe this issue should have been decided before this proceeding was held?
I can't really answer that in the abstract. I just think it's helpful to have district judges who rule on evidence and procedural issues and the sentencing guidelines all the time. So you're really familiar with those things. You tend to get a much better decision from judges who rule on those matters a lot, just because you get used to it, especially evidentiary issues for a district judge. If you've had a lot of trials, you just kind of know the federal rules of evidence, and you're not right all the time, but you know, at least you have a lot of background in it. So I would say those kinds of issues where, I mean, there's not a lot of Appointments Clause cases. We can agree on that.
Sure.
So this is something that the district judge probably hasn't had before. But there are a lot of due process and procedural questions, confrontation of witnesses, protections. There's a lot of those cases that we have as district judges. So it's really just, are you getting a lot of experience with those issues with the particular judge or administrative law judge?
Peggy, since we're coming to the end of our time, I just wanted to throw it to you for a minute to see if there was anything else that we didn't get to that you wanted to be sure to include in the luncheon law today.
I think it was pretty comprehensive. It was a real pleasure to talk about these issues with someone who's been on the other side of the bench and looking at them and to see what, you know, an honest application of those factors leads to. I think that's a key takeaway from today's event.
And Judge, I'll give you the last word. You were one of the people who got this ball rolling with your excellent dissent in Tilton, and really appreciate your being with us today, but give you any final thoughts that you have or takeaways that you might have for the audience.
Just thanks for having me participate. I learned quite a bit too about these issues, and keep up the good fight. I mean, I think the Tilton dissent was correct, and still do. And I'd like to see me vindicated by the Supreme Court someday. So.
Well, we will do our best. Thank you, Judge Droney, very much for your participation. Thank you, Peggy, and thank you, audience, for tuning in. It's been a delight to do this luncheon law, and we look forward to having another one for you soon.